All right. Good afternoon, everyone, and thank you for joining us. My name is Kate Lawrence, and I am with the Cincinnati Bar Association, and it's my pleasure to welcome you to today's presentation on Ohio Issue 1. Before I introduce our speaker, I'd just like to make you aware that if you are joining us on Facebook and you'd like to ask any questions or make any comments about the program, you can enter those into the comments on Facebook. If you're joining us on Zoom, feel free to enter any questions into the chat feature, and we will have some time after the presentation to take questions. So I'd like to welcome our speaker today, Professor Kenneth Katkin. He's joining us from the Salmon P. Chase College of Law at Northern Kentucky University. And Alan Abes with Dinsmore and Scholl, he will be moderating our Q&A. So to introduce our speaker, Professor Kenneth Katkin appears frequently in local and national media as an analyst for current legal issues and trials. Prior to coming to Chase in 2000, he litigated constitutional and telecommunications law cases in Washington, D.C. His clients included America Online, CBS, McCain for President 2000, the Media Access Project, Pacific Bell, Southwestern Bell, Clear Channel Communications, and the Washington Legal Foundation. Before entering private practice, he was a law clerk for Judge David M. Abel of the United States Court of Appeals for the 10th Circuit at Denver. Before attending law school, he worked as an artist and repertoire director for several independent record companies and as a non-commercial radio disc jockey and talk show host. Professor Katkin holds a JD from Northwestern University School of Law and a Bachelor of Arts in Mathematics from Princeton University. So it's my pleasure to go ahead and turn it over to Professor Katkin.
Thank you. That was a very kind introduction. Okay, well, I'll get right to it. A lot of you are interested in Ohio Issue 1. Early voting is already open. Probably some of you have already voted and you're just here for the CLE creditor to learn a little more. And election day is the August 8th. So I think what I'm going to try to do in the time we have together is start, because I am a constitutional law professor, talking about sort of some constitutional theory around what the arguments are for and against representative democracy versus direct democracy. And then I'm going to look a little bit at the history of the current Ohio Constitution. The current provisions on initiative and referendum date back to 1912, and I'll talk about that a little bit. And then I'll sort of go through the nuts and bolts of what changes Issue 1 would make. And then perhaps survey a little bit of the history of what kinds of things have actually been accomplished through citizen initiative and referendum in Ohio over the past century. Now, I made notes that are really just lecture notes for myself, but I've noticed that my students usually like it when I put those up while I'm using them. So I am going to do that here. You can feel free to look at them or ignore them. Most of what's in them, I'm probably just going to say anyhow. But I'm told I have a face for radio, so you'll probably prefer to look at the lecture notes. So I'm going to start out with this big question. You know, why would we prefer representative democracy, or why would we prefer direct democracy? What are the benefits and costs of having a legislature make laws versus having the people vote on laws directly? And there certainly are some arguments for direct democracy. Direct democracy ensures that laws will reflect the will of the people, right? Every time the people vote on a law, you have a lot more certainty that a majority vote accurately gauges the will of the people than you would if it was just whether the legislature is accurately reflecting the will of the people. Direct democracy can be a bulwark against legislative corruption by special interests. So, you know, we've all recently seen various federal criminal trials here in Cincinnati, both of local city council members and of state legislators in Columbus. At least the US Justice Department believes that there was significant corrupt capture by special interests in Columbus, especially related to the first energy bailout. And so direct democracy can sometimes be a bulwark against that kind of thing. Direct democracy may distribute political power more equitably. When we take issues to the voters, every single voter has one vote. when we resolve things in the legislature, donors and more powerful interests may have more access, and their votes may count more than those of the ordinary people. Direct democracy tends to be opposed most by those who already enjoy disproportionate political power. And direct democracy promotes transparency and civic participation. When you put something on a ballot, you bring the general public into politics in ways where they see what's going on, and they get the both the personal benefit of being civically engaged, and perhaps society gets a benefit when the public is more civically engaged. So those are sort of the general arguments for direct democracy. Now there's arguments for representative democracy as well. The most obvious one is the practical one. Society needs a lot more laws than the public could possibly enact. There's simply no way, that we could have the Ohio legislative code that we have if everything was put on the ballot, and there's a lot of laws that are actually necessary, and we can't have election day every day. There's also countervailing concerns about special interests. One concern would be that even though we might think generally that special interests could corrupt a legislature, it's also the case that special interests will play an outsized role in determining what questions will go on the ballot, because it takes resources to marshal a petition drive and to collect signatures and to advertise and promote a ballot initiative. And so generally, who's going to invest in that kind of thing? Well, it might be generally the special interests that have the most at stake. Representative democracy, as opposed to ballot initiatives, may be seen as doing a better job at facilitating deliberation and compromise, right? So if you've got different sectors of society with different agendas and different goals and different objectives, in a legislature, there can be some log rolling and some vote trading and some changes made to initial proposals to kind of get to something that everybody can live with. That can't really happen in direct democracy. You're just putting questions on the ballot and giving them an up or down vote. There's no deliberation or compromise. Finally, the general public may be less capable than a legislature of weighing costs and benefits or considering consequences. It might be the case that if you put it on the ballot today, should we eliminate all taxes in the state of Ohio? Something like that might possibly pass because people don't like paying taxes, but they actually need some of the services that the taxes pay for, but they wouldn't factor that in properly. So there's those kinds of arguments, I think, generally for representative democracy. And I just wanted to start with all that before we get down to any technical or nuts and bolts stuff, to think about, these are all serious arguments on both sides, and there's no obvious one size fits all solution about how much direct democracy should we have, how much representative democracy should we have. They each have their virtues and their costs. One other constitutional theory question I want to talk about for a second before I move on to the issue one stuff is another thing about both ballot initiatives and legislatures is, we're sort of starting out with this idea, well, which one better reflects the will of the majority, or perhaps the fully informed will of the majority if the majority understood everything better. But it's also the case that in constitutional theory, there's reasons that we don't always want the laws to reflect the will of the majority. Sometimes reflecting the will of the majority is not the right thing. And in fact, that's why our US Constitution, for instance, both limits the power of the Congress and gives us a Bill of Rights and other kinds of additional limitations on the power of the government. So there's a lot of things the United States government can't do, either because it doesn't have an enumerated power to do it or because it would violate the Bill of Rights, which are things that majorities would want the government to do. And so we always have the question, why would we ever do that? Why aren't we looking for a system that best reflects the will of the majority? Why would we ever want to disable government from doing what the people want? And I'll just say, there's a lot of theory about that, but I'm just going to point to a few of the most commonly cited reasons. protection of minorities against majoritarian tyranny. It's easy to see that kind of thing in American history. We had slavery in many states because most people wanted slavery in those states. The slaves didn't, right? So it's possible for majorities to codify bias or animus or prejudice against minorities in ways that oppress minorities that we might just think are never, now we might think are never acceptable. Also, we might think we don't always want government to be perfectly responsive because we want to have some protection against excessive responses to temporary passions. So we might look at something like when Pearl Harbor happened, one of the ways that the US government responded was to put all the Japanese American citizens of Japanese ethnicity who lived on the West Coast in concentration camps for the duration of the war. And looking back, that's very broadly seen as an overreaction. Congress actually passed a reparations bill in the 1980s for people who had been interned, and President Reagan signed that into law. And so some people say, well, it's good to have a constitution that prevents the government from quickly overreacting when there's just sort of the mob with the pitchforks out there demanding that something be done. Constitutionalization can also create legal stability that facilitates private planning and investment. So if we had a legislature, again, that could be all powerful and make whatever changes the public wanted, that might form a disincentive to planning and investment. You might not want to build a business if you were afraid that the business could be just nationalized the next day or something like that. So Constitution provides stability. And it just generally provides the ability to maintain a private sphere that's separate and beyond the reach of the public sphere. So I think these questions are not obviously on the surface of the issue one debate, but they're all there, right? So we have the question of how do we best design a system that will reflect majority rule, but we also have the question of, do we want a system that perfectly reflects majority rule, or do we want to have some carve-outs where majority rule can't easily be implemented? Okay, well, if you made it this far, I promise I'll stop talking about theory now, and I'll start talking about more practical stuff. So some of you are probably interested in how we got a citizen ballot initiative and referendum in Ohio, when we got it, how widespread it is, why we got it. Citizen ballot initiative and referendum, you all probably know, is not a feature of the US Constitution. So there's no similar process where the public can propose an amendment to the US Constitution and get it ratified. There's a couple methods in the US Constitution to ratify amendments. Usually the only one that's been practical is for a supermajority in the House and the Senate to send a proposed amendment out to the states, and then 3/4 of the states have to ratify it. There are other ways it can be done. It can be done by a petition of a large number of states, or it can be done by a new constitutional convention, which is something that's never happened for the US Constitution. But there's no citizen process, and similarly, there's no citizen process for enacting statutes, federal statutes. The only way a federal statute can ever get enacted is by bicameralism and presentment. It has to pass the House of Representatives. It has to pass the Senate in identical language. It has to be signed into law by the president. So not only was the citizen ballot initiative and referendum not part of the US Constitution, but it also is not part of the Constitution of any of the original 13 states, although there's limited versions of it that were later amended in Massachusetts and Maryland, and currently are parts of those constitutions, but generally didn't get much of a foothold on the East Coast. The movement for citizen ballot initiative and referendum started in the West, and South Dakota was actually the first state to add this to their state constitution. It happened in 1898. And I think a lot of the sort of political momentum behind this in South Dakota was a populist movement that was particularly concerned that in these small Western states, and South Dakota then as now had a very small population, it had a lot of things that were of interest to out-of-state corporations, right? The railroads came through there. There were mining interests there. There were large agricultural interests there. And the people of South Dakota felt that these out-of-state moneyed interests essentially owned the state legislature, and that the state legislature was much more accountable to out-of-state moneyed interests than to local South Dakotans, sometimes to the detriment of the local South Dakotans. And so they wanted to have a check on their own legislature. And that really was the sentiment behind why South Dakota adopted the citizen initiative. It was essentially because they didn't trust their legislature. And that was a view that in the populist West of the late 19th century was widespread, and citizen ballot initiative and referendum spread pretty quickly throughout the West once South Dakota did it. And then it started spreading east after that. Ohio was almost at the end of that period of expansion. So Ohio became the 13th state, and there's now 18 to adopt citizen initiative and referendum to amend the state constitution. There's a total of 26 states that have some form of citizen petition and referendum, but 8 of those states, that's limited only to citizen initiated statutes and not to citizen initiated constitutional amendments. But Ohio became the 13th. This happened in 1912. Ohio had a constitutional convention in 1912. That was our 4th constitutional convention, 4th and final. We've never had another one since then. Although some of you will remember, if you voted here in 2012, that one of the amendments that was actually adopted in the 1912 convention does require a ballot question every 20 years about whether we should have another constitutional convention. So we had one in 2012. We'll have it again in 2032 on the ballot. But the voters have always rejected the idea since 1912 of calling a new constitutional convention. But we did have a big one in 2012. The Theodore Roosevelt, who was no longer president, he had just left the presidency. He came. He was a big supporter of ballot initiative and referendum. He said, "You are framing a constitution which the people are to get and do justice and to rule themselves." Roosevelt told the convention, "If there must be a decision by a close majority, then let the people vote and let it be their majority that decides." So he came to be a proponent of this. Other notables spoke in favor of the ballot initiative referendum at the 1912 convention, including William Howard Taft, William Jennings Bryan, Hiram Johnson, and others. And the 1912 convention, which was presided over by Reverend Herbert Bigelow of Cincinnati, he was the pastor at the Vine Street Congregational Church. They did adopt the citizen initiative and referendum, and they also adopted a lot of other amendments at that convention that remain kind of sort of tent poles of Ohio law. The 8-hour workday for public employees, minimum wage laws, maximum hours laws, our worker compensation system, all of that came out of the 1912 Constitutional Convention, along with the ballot initiative and referendum. And in some of the other Western states at that time, ballot initiative and referendum was used in important ways. For instance, in the same year that Ohio adopted ballot initiative and referendum, Oregon used it to give women the vote. And this was 8 years before the 19th Amendment was ratified. So the general public in Oregon went to the polls and gave women the vote. The legislature did not do that. So that's sort of some early history. Now let me take a quick look at I'm having a little difficulty because of the way the Zoom screen looks, reading the language here because my own picture's blocking it, but I'll do my best. Ohio, the current Ohio Constitution, which I put on your screen here, reflects the 1912 language. So the structure is that generally the voters, the people vest legislative authority in the legislature. And the General Assembly, which consists of a Senate and a House, is the primary lawmaking instrument of state government. But the people don't vest all authority in the legislature. The people reserve to themselves certain legislative authorities, and this includes the authority to overrule statutes directly. the authority to enact statutes that the legislature hasn't enacted, and the authority to propose and ratify constitutional amendments that the legislature doesn't propose or recommend. So all of those have been features of the Ohio Constitution since 1912. They're codified directly in Article 1, Section 1, and then there's some subsections after Article 1, Section 1 that talk about the details and technicalities of how that works. So in reality, the vesting of legislative authority in the legislature remains overwhelmingly the primary method for lawmaking in Ohio. The legislature has vast powers to make Ohio laws, and in fact makes virtually all Ohio laws. But we do have these few forms of direct democracy. First, by public referendum, the Ohio Constitution does let Ohio voters simply repeal a law that was recently enacted by the General Assembly. So that's something that the voters can always do. That doesn't involve a constitutional amendment. That just involves the legislature has passed a law. Some people don't like the law, so they collect signatures, and the voters overrule and rescind the law. That is a relatively easier process to use than the constitutional amendment process. It requires 6% of the voters, the number of voters in the state who cast a vote in the most recent gubernatorial election. So that's always the denominator, the number of voters who voted in the last gubernatorial election. So then the number of petitions to rescind a statute would be 6%, and they have to be signed by at least 3% of the voters in at least 44 counties out of the 88. And that will put this repeal initiative on the ballot. And again, this would not change the Constitution. This just simply repeals a statute. It can't be used for statewide tax levies or legislative appropriations to fund the government. Can't be used on measures that the legislature has enacted as emergency measures, although the legislature would need a supermajority to use that process. And it was recently used, or at least in recent memory of some people, to repeal SB 5 in 2011. That was a statute that the legislature enacted that would have ended the government engaging in collective bargaining with public sector unions. And that was opposed by the people. The police union and the firefighters union and teachers unions all were pretty active in trying to get that overruled, and they succeeded. Now, I point that out. That's not actually going to be affected at all by issue 1. So the issue 1 does not address the process in section 1C of the Ohio Constitution that allows the public to repeal recent statutes. So that'll still be available whether issue 1 passes or not. Another form of direct democracy in the Ohio Constitution that will still be available whether Ohio issue 1 passes or not. Section 1B actually allows members of the general public not only to repeal statutes that the legislature already enacted, but also to enact statutes that the legislature never enacted. So if there's something that people think there ought to be a law about and that law just doesn't exist, again, the same process. You need an even lower number of petitions, 3% of the number of voters who voted in the last gubernatorial election, with at least 1.5% of those voters in each of the 44 counties out of 88 is enough to get a new statute on the ballot. And then that can also be ratified by a simple majority. That process also will not be affected by issue 1. So we'll still have statutory ballot initiative and referendum by simple majority and statutory repeal of legislative enactments with a simple majority. Now, the other things that we have for direct democracy would be affected. So everybody knows this one, but Section 1A of the Ohio Constitution allows voters to put a constitutional amendment on the ballot. Now, this is already a much harder thing to do than putting a statutory proposal on the ballot. It requires a much larger number of signatures, 10% of the number of votes cast in the most recent gubernatorial election. And just to give you some meat on those bones, the last gubernatorial election, there's 4.13 million votes cast for governor. So So there would need today to be 413,487 signatures on a petition to amend the Constitution. They would all have to be valid signatures, and every one of them is definitely going to be checked. And they right now have to come from at least 5% of the voters in at least 44 of the 88 counties. Now, if that high hurdle is just to get something on the ballot. Once a constitutional amendment is on the ballot, it still requires a simple majority vote. But interestingly, this hasn't been achieved that many times. There have been 125 constitutional amendments adopted in Ohio since 1914, which is a lot, but only 19 of them were placed on the ballot by citizen initiative. So the large majority of those 125 constitutional amendments that were adopted were placed on the ballot by the legislature, and we'll talk about that process in a minute. Also, besides the 19 citizen initiatives that got on the ballot that the voters have adopted, there have actually been 52 more that achieved the requisite number of signatures to get on the ballot, but then the voters rejected. So the voters seem to be fairly skeptical of citizen initiatives, even when they get on the ballot. Again, they've only adopted 19 out of 52 of those in 100 years. Now, there was one just certified, and I'm sure you're all aware of this. It happened yesterday. So yesterday, the Secretary of State certified that there were 495,000 valid signatures for the reproductive choice proposed constitutional amendment, and that will be going on the ballot in November. Now, I should mention that out of the 495,000 signatures that were accepted as valid, that's out of 800,000 that were collected. Right, so 800,000 signatures were collected. About 3 out of every 8 were struck as invalid, but there were still enough, so that's going on the ballot, and so we'll see what happens, and we'll talk about that a little bit later. Another thing that happened, there was an amendment, a citizen, one of the 19 citizen initiative amendments that did pass was and the most recent one, gave us casino gambling here in Cincinnati and in 3 other cities. That was largely financed by the entities that were going to own those casinos, and it limited the number of casinos that could be granted to just a few, which were owned by the sponsors. And there was, although the voters did accept that one, and again, they've only accepted 19 out of 61 or 71, there was a lot of criticism that this was the improper use by special interests to advance their own interests, the casino interests, which succeeded in getting this through and then owning those casinos. There was then a legislative initiative amendment that was accepted after that, that says even if the requisite number of signatures come in for a future citizen-initiated petition, it can't go on the ballot if it proposes to give any specified entity rights that would not be available to other similarly situated entities. So the type of casino amendment that gave us casino gambling but limited it to certain owners who were sponsors of the petition, that would no longer be a valid form of citizen initiative anymore. Now, I will say, for reasons I'll talk about in a minute, if issue 1 passes, you will not see very many citizen initiatives anymore. And we did only see 19 successful ones in 100 years, but I think that rate would go down extremely substantially. There's a few other methods for passing constitutional amendments. The one that's actually the most common is that the General Assembly can place an amendment on the ballot. So this would not be citizen initiated, but it's still a form of direct democracy because the citizens would need to ratify it. Right now, that's by a simple majority vote. The legislature has done that a number of times in the past 100 years. There have been 125 amendments adopted since 1914. And as I mentioned, 106 of those were placed on the ballot by the General Assembly. And there was another 32 placed on by the General Assembly that the voters rejected. One of the main reasons that the General Assembly has to place so many constitutional amendments on the ballot rather than just simply passing legislation, you might be thinking, why are they always doing that? Why don't they just pass legislation instead of putting everything to the voters? One of the main reasons that happens so frequently is because our Constitution, since 1851, is essentially running a balanced budget. There can be a state debt, but it's capped at $750,000, which in today's dollars is something like zero. So it's not actually legal for the legislature generally to issue bonds without a constitutional amendment. Anytime they would want to issue a bond to do anything, they would need a constitutional amendment. And so we typically see popular initiatives that would require bond issues presented to the voters. So a few examples here, recent ones in 2000 and 2008, Ohio voters amended the Constitution to allow bond issues for Governor Taft's Clean Ohio Fund. 25 and 2010, Ohio voters approved bond issues to Third Frontier program, which was another Taft initiative to try to have a tech incubator in Ohio. So these kind of things do require a constitutional amendment because the debt ceiling in the Constitution would otherwise prohibit them. Now, similarly, although it's largely being seen by the public that issue 1 would mainly prevent citizen initiatives for constitutional amendments, issue 1 would also do a great deal to make it harder for the legislature themselves to propose and pass constitutional amendments, because some of the changes would apply to both kinds, particularly the change from a 50% vote to a 60% vote that I'll talk about in a minute. The last thing I won't say too much about, but in principle, we have direct democracy in the form of we do have to be asked every 20 years whether we want a whole new constitutional convention. That's a feature of our Constitution. And although it's been 100 years since the voters have said yes to that, in principle, our Constitution expires every 20 years. And so the public has to re-ratify it every 20 years or scrap it. Okay, so what are the precise technical changes proposed? Well, remember, there won't be any changes to the statutory initiative and referendum processes. Citizens will still be able to overrule the legislature to enact statutes the same as they have for 100 years. But for the constitutional parts, there's really going to be very severe restrictions imposed that I would say would make it very unlikely that you'd see very many citizen initiative passed anymore. And some of these are less obvious than others. One is the doubling the geographic diversity requirement, right? So this may sound like a technical thing, but it's a very, very impactful thing. Because Ohio has 88 counties, and some of those counties are very, very small. And some of those counties are very, very hard to do petitioning in, because it's just hard to even find places where you could see people out in the street and approach them to ask them to sign a petition. And also, you know, frankly, those are the counties that are the most Republican. And so the current, you know, the current system, you know, requires 10% of the number of active voters in the state to sign a petition, but it requires some geographic diversity. There has to be at least 5% of the voters in half the counties, 44 counties. But the number 44 would be changed to the number 88 now. So there'd have to be at least 5% of the voters in all 88 counties. So if even one county didn't get 5% of its voters to sign a petition, that petition would never go on the ballot. Now, remember, of the 88 counties, 39 of them, that's almost half of them, are extremely small. 39 of them have populations below 50,000. The least populous counties all have populations around 15,000. These small counties all slant heavily Republican. In fact, in the 5 smallest counties, you each have fewer than 2,000 votes for President Biden in 2020. You know, compare that to the 250,000 votes that President Biden received here in Hamilton County and the 177,000 votes that President Trump received here in Hamilton County. And you can see that it would be really probably a chore to find 5% of the voters in those counties who would sign these petitions. So, and certainly that's never been done in the past. There's never been any citizen initiative with support in all 88 counties, and people haven't really ever tried to canvass these small counties. So that's a reasonably severe restriction. In fact, I just looked, you know, yesterday, as I mentioned, 800,000 signatures were collected for the abortion initiative, 413,000 were needed. Of the 800,000 collected, About 500,000 were deemed to be valid, and that was enough. So that abortion initiative will be on the ballot in November. But those signatures were collected in 55 of the 88 counties. So that clearly it surpassed the 44 that are required, but it would be nowhere near, the 88 that would soon be required. So this would have been a dispositive difference for getting that on the ballot. On the other hand, it doesn't change the number statewide. The 10% statewide remains the number. So another big change. I forgot to do the comparative stuff. I'm sorry. I did look comparatively. If we require signatures to be collected in every county in the state, we will be the only state that does that, and so that would be the most stringent requirement in the country. There are other states that do have some geographic distribution requirements, as we also currently do with our 44 county requirement. And I just sort of put them up on the screen. I hope you can see them. But all of them, none of them have a unanimity requirement. Many of them have a requirement of a certain number of counties, or, in some of the states where you have one very big city that dominates the state, like Maryland or Massachusetts, you just have requirements that a certain percentage of the signatures come from all other counties, but not from each other county. And then in Colorado and Nevada, they have systems where they use regions of the state. They require geographic diversity by region, but not right down to the level of county. So geographic diversity is a common feature. Of course, it's currently a feature of our present Constitution, but this amendment would require a more stringent and more hard to comply with geographic diversity requirement than at any place else in the Union. I also, because I teach law, I did look into whether there's been any litigation about this. There is a small circuit split on it. The Ninth Circuit Court of Appeals found and held that county level signature requirements violate the Equal Protection Clause of the 14th Amendment because the counties in California vary so drastically in the size of their population, as ours also do. And so they found that giving these tiny counties a veto over the larger counties essentially violated the requirement of one person, one vote. However, the Eighth Circuit held exactly the opposite, and this has never come up in the Sixth Circuit where we are. Another thing that issue one would do, and I'll try to wrap this up soon because I know you want questions and answers. Issue one would eliminate the grace period that's currently part of our process. If the signature elimination leaves the petitioners short. So I mentioned a minute ago that for the abortion initiative that's going on in November, 800,000 were collected, 300,000 were struck as invalid, but the 500,000 that were left was still enough. Well, suppose that 400,000 had been struck, and so the petitioners were now a little bit short. They still had 400,000, but they needed 413,000. Our current Constitution gives them 10 days to run out and get more signatures. And this would change that and say if the signature elimination process happens, and before that they thought they had enough signatures, but now they found that they don't, then they're done. And they've got to start all over again in a future election cycle. So that again would, because so many signatures do get struck, and in fact, because it's not that uncommon for opponents of signature petition efforts to go out and actually put fake bad signatures on petitions of their opponents just for the purpose of trying to invalidate the petitions. I think that this would be a more significant impediment than it might first appear. It sounds kind of just like a technicality, but a great number of signatures are usually eliminated during the verification process. So eliminating the grace period to get more signatures, if that happens, would probably derail a lot of petition drives. And finally, this is the part you all know about. The number of votes would go up from 50% to 60%. And of course, that would be significant. There have been 20 constitutional amendments ratified in this century, and 5 of them were ratified with less than 60% of the popular vote. So this would have derailed those bond issues that I talked about in 2000 and 2005. These were bond issues that were supported by Governor Taft, had bipartisan supermajority support in the legislature and were accepted by the voters. But if we would have had the 60% requirement, they could not have gone through. This also would have meant that the minimum wage increase and the casino gambling legislation wouldn't have gone through, as well as the anti-monopoly amendment that was a response to the casino gambling legislation. So that one wouldn't have gone through either, and we would have still been allowed to have citizen ballot initiative used for special interest ballots if the 60% requirement had been in place. Yeah, that's, I got to wrap it up. I did sort of put up a chart here, and if any of you email me, I'll send you the chart. This was also published in the Cleveland Plain Dealer, so you can find it there. But this shows every initiative since we've had citizen initiative, every constitutional amendment that passed with between 50% and 60% of the vote. And you'll see there's some big ones in there. Alcohol prohibition, maybe that wasn't a good one. Maybe that would have been better to derail with a 60% requirement. We removed the word white male from voter eligibility. 56% of Ohioans voted to do that, but not 60%. Our Constitution might still today say that only white males can vote. Of course, that wouldn't be enforceable because of federal constitutional amendments, but that might still be the language of it. We had we used to have an option on the ballot to just say, to click Democrat or click Republican, and then you would, by doing so, wouldn't have to vote for all the offices. That was changed by citizen initiative, but it didn't get 60% vote. Women being allowed in the National Guard, expansion of the Court of Appeals, and again, most recently, both the minimum wage increase and the casino gambling, as well as the anti-monopoly amendments. So these are some examples of things that would have been impacted by that. I did also look at other states to see, you know, of states that have ballot initiative and referendum, how many require supermajorities and how high of a supermajority. Well, most of them do require supermajorities. So simple majority is the minority. But none of them, or only one of them really requires a supermajority as high as 60%. So we would be moving from being kind of on the more lenient end to being on the very strict end. So you'll see on the slide here, different states have different numbers. New Hampshire requires a 2/3 vote, so that would be higher, but New Hampshire is not actually a citizen initiative state. So this is already a state that you can only get constitutional amendments if they're proposed by the legislature. Florida would be the only other citizen initiative state that has a 60% requirement, and the remaining ones, as you can see, would be lower. In Colorado, it would be 55. In Hawaii, Minnesota, and Wyoming, it is 50, but they count a non-vote as a no vote. So it has to be 50% of the people who actually vote, not just more than the people who vote no. In Oregon, interestingly, they put in an amendment prophylactically to prevent something like our issue 1 from happening. So in Oregon, if anybody proposes to raise the 50% to a higher number, that amendment can only be ratified by the number that it proposes. So in other words, in Oregon, if issue 1 was on the ballot, issue 1 would require a 60% vote to pass, but other amendments would still only require a 50% vote to pass. So they've actually put in a prophylactic against this kind of initiative. So anyhow, if issue 1 passes, of all the states that have citizen initiative and referendum, Ohio would jump from being tied for least restrictive to being tied with Florida only for most restrictive. And of course, if Ohio 1 does pass, it's not going to get 60% of the vote. So Ohio 1 would not pass if Ohio 1 was already in effect. Finally, the near future, and then I promise I'll stop. The big issue is abortion rights. You know, this is clearly on the ballot because of the abortion initiative that'll be on in November. Everybody saw that one coming after the Dobbs decision. Secretary of State LaRose told attendees at a Lincoln Day dinner that this is 100% about keeping a pro-abortion amendment out of our Constitution. There's going to be a ballot initiative in November. That ballot initiative is going to pass if the 50% remains the rule. And so clearly, I think, you know, in the general public's view, that's the main issue here. And in my view, that's also the main issue here, that's the reason that the legislature, in fact, put this on an August ballot. just a few months after they actually made August elections illegal. Then they made an exception for this one because they really needed it on there before this November because of the abortion initiative this November. There's other issues probably that will be affected. A $15 per hour minimum wage initiative is on its way. It won't be on this November, but there's a likelihood it'll be on in November of 24. And it's probably going to be the case that the 50% versus 60% threshold will make the difference. The last minimum wage citizens initiative got 56% of the vote, so right in the center of that range. Recreational marijuana initiatives have been a lot before. They have not passed. It's hard to know whether they would pass or in fact whether the legislature might eventually pass recreational marijuana. But you have to think that at least that there would be more initiatives coming, and a 60% requirement would certainly torpedo them. 50% requirement, they might not pass anyhow, and they haven't before. Finally, the public finance stuff I mentioned. This is a little bit of an outlier compared to the other stuff, but with public debt, typically a public debt issue would only get on the ballot if it was already supported by the legislature and the governor. In fact, it takes a 3/5 vote in each house of the legislature even to put it on the ballot. So these are generally, unlike the other ones, not situations where the voters are trying to do something that the legislature won't do, or the opposite of what the legislature did. Bond issues, it's usually the legislators just trying to get public support for a bond issue. But none of the recent ones have got a 60% vote. So I would say that if issue 1 passes, we would be in a situation where it would be much harder for the state of Ohio to issue bonds, even when the legislature and the governor wanted to do that. I think I'll stop there because I promised not to go even as long as I already have. And I would like to open this up for questions about anything at this point.
Well, thank you, Professor Katkin. Really appreciate it. Again, I'm Alan Abus. I'm on the CBA Board of Trustees, and we do have a few questions that I will moderate and present to you. So first question is with respect to the requirement for signatures in all 88 counties. If issue 1 were to pass, that provision would not be retroactive for the Reproductive Rights Amendment, would it? So because the Reproductive Rights Amendment only achieved the threshold in 55 counties, it would still be on the November ballot, but it would still be subject to the 60% approval threshold. Is that right?
That's precisely right. But I do think the 60% approval threshold would torpedo it. Most of the polling shows support for it around 55, 56% right now. So I do think that the outcome of the November ballot initiative will be determined by the August ballot initiative, but it will definitely be on the ballot.
Then we've had a couple of questions about potential alternatives, and these relate to the initiative petition and referendum procedures that are statutory rather than constitutional. So can the legislature repeal a law that is enacted by initiative petition?
Yes, they can do it immediately. Now, there's a history of them not doing it, right? So, for instance, if you look back at the episode in 2011 that I mentioned about SB 5, so the legislature enacted a law that would have prevented any government units in Ohio from engaging in collective bargaining with public sector unions. That was a statute. The statutory repeal mechanism was used to repeal that. And it has stayed repealed. They have not tried to reenact it. And I think that's the general tradition. But if they, as a matter of raw power, they probably would. And I do think, again, abortion would probably be, it's such a hot button issue for everybody that I think that might be the one where you would see them try to reenact it if a statutory mechanism was used.
So the legislature's powers goes both ways. It could repeal an initiative petition, or it could reenact a statute that was repealed by a referendum.
Yep.
Is there any way to find out whether your signature in particular was one of the ones rejected by the Secretary of State?
That is a wonderful question. In theory, the answer is absolutely yes. That's a public record. In terms of how to actually do it, you're beyond my abilities with state administrative law. I suppose if you filed a Ohio Open Records Act request on the Secretary of State for that information, he would have to respond to it.
And then we had a related question in the chat. How long are the signatures valid? In other words, once a signature is acquired, how long can it last, or is there no expiration on it, just subject to the person staying alive, being a registered voter, et cetera?
Yeah, I guess if someone wanted to rescind a signature, could they do it? I don't think they can rescind a signature if it's otherwise valid. But if things happen like they die or they move, so they're not any longer at the address they were at when they signed it, they will be invalidated. And of course, all of them will be invalidated if the petition doesn't get on the ballot, right? So if you have a situation, say, where because of the process of invalidating some of the signatures, you still had a lot of valid signatures, but not enough to get it on this ballot, those would not carry over to a future ballot. They would all be invalidated, so you'd have to start again.
Then we've had a couple requests for materials. I don't know that you necessarily want to put your lecture notes out there, but you did offer to send the chart. Are there any materials that you can provide or recommend for people who want a written summary?
Yeah, I actually will send my lecture notes to anyone who wants them, and they can email me. My address is on the NKU Chase website, or I can provide them to CBA and they can get them there. But also, a lot of the data that I was using, I found on a website called Ballotpedia. And Ballotpedia is a very good website if you're looking for data about this kind of stuff. And people could, if they're just looking for some of these raw numbers I had about, how many times has this happened, what states have done this, what rules. My main resource for that was the Ballotpedia.
Appreciate it. Kate, that's all the questions we have at this point. I know you've invited any other questions, but don't see any right now.
Yes, I am not seeing any other questions. So if anybody has any last minute, feel free to enter them in the chat. Otherwise, I would like to thank Professor Katkin for being with us today. This was extremely informative and we absolutely appreciate your time. And thanks to Alan for moderating our Q&A. Not seeing any other questions, so we will go ahead and wrap things up. Thank you, everyone, and have a great afternoon.